on information privacy, and he is here now with me. His name is Boris Segalis. He's a partner at InfoLawGroup. And Boris, Mr. Segalis, oh, you're too young. Boris, good to see you.
Sure.
First of all, before we get into the ramifications, that this is a whole kind of convoluted, complicated situation. So initially, employees didn't have the freedom to blog or post, disparaging marks about their boss on the internet or anywhere. All right. And then they said, this case came up and they said, no, you can go ahead and blog. You have the freedom to do that. I don't know. What's going on?
Well, what happened was, before this case came about, a lot of employers had these very restrictive social media policies. So they would say that you can't depict the company in any light on Facebook or other social media, or you can't, or outside of work, or you can't make disparaging remarks. And that was sort of par for the course. So this case is interesting in that the story is different now. The situation changed because the federal government, or the National Labor Relations Board, said that sort of dissing your employer and your management is a federally protected right. So this is certainly going to change how employers write their social media policies, and
there's
what sort
limits.
of restrictions.
You can't defame or make comments about your boss that perhaps put his life or his security in jeopardy.
That's right. This right is limited. It's in the context of your of employees' right to unionize. So you can discuss your wages, you can discuss your working conditions, you can discuss your management with other employees. So if this discussion is not with other employees, or if it is sort of defamation, where you're just disparaging a company without having any basis for it, then that sort of conduct is not going to be protected.
However, being clear on this, at this point, if a person wants to get online and get into some chat room and talk about, your work day, your workplace, and just sort of how things are run, they have the freedom to do that, even if it's not hunky-dory.
That's right. That's right.
So what does this mean in the end? What does this mean for businesses?
Well, what this means for businesses is that they need to look at their policies, social media policies that are up to now have been very restrictive. Look at this settlement, and we can talk about it, the settlement itself, and make sure that their policies are in line with their business needs. So obviously, employers want to protect the companies against disparagement, against bad publicity, but at the same time, allow employees the right to talk about the companies and management on social media and outside of work. And employers will no longer be able to dismiss employees or punish them for this sort of conduct.
And the case that precipitated this whole dialogue here is what? Give us the details on that.
Well, in this case, it's an ambulance company in Connecticut, and an employee was required to respond to a customer complaint. She was unhappy about some of the aspects about her interaction with her manager, and essentially started making disparaging remarks about the manager in connection with that dispute on her Facebook page. And other employees chimed in, so it was sort of like a group discussion. She got fired. The employer had a very restrictive social media policy. It said that you can't depict the company in any way on Facebook or other social media, and you can't make discriminatory or disparaging remarks about management or the company. So this is a very sort of tight policy, and the employee got dismissed. So the National Labor Relations Board, which is the federal agency that's in charge of protecting employees' right to unionize, sued, which is very rare in itself, saying that this sort of policy violates an employee's right to unionize. And whether the employee is unionized or non-unionized, any employee has that right. The case ended up settling very quickly, I must say.
So they settled. She didn't get her job back, though.
Well, there were two parts to the settlement. First of all, the company committed to change its practices and to change its policies. And there was a second part. There was a private settlement between the company and the employee over the dismissal.
I'm sorry, what was the second thing you said?
There was a second part of the settlement between the company and the employee that settled the question of her dismissal. She probably got some settlement from the company.
Okay. Do you want to chime in?
Well, I think that there are two issues here. I mean, I think that we're talking on the one hand about the right to unionize. On the other hand, we're talking about free speech issues. And I think that part of the difficulty is determining who has access to this information. If we're talking about a very closed circle of friends who